Ron Sullivan on behalf of Aaron Hernandez.
Linda Kenny Barton on behalf of Aaron Hernandez.
George Lee and Tyler on behalf of Aaron Hernandez.
All right, good morning, folks. Seated with me is a new member of the Superior Court. I'd like to welcome Judge William Barrett, who was inducted into this court last week and will be sitting as part of the court's welcoming and training program. Judge Barrett will be present, I think, in the morning, as we had a couple of weeks ago, another justice, Judge to beat. And Judge Barrett's presence here is not indicating any emphasis by the court on the importance of any testimony and will not be grounds for a mistrial. Now, I've received this morning a motion to dismiss that I hear one side or the other one to be heard on. Who wants to speak to this? Yes, sir.
Your Honor, the motion to dismiss is based upon the use of the prosecution of perjured testimony. I believe the court would recognize that the use of perjured testimony is one of the most areas which the courts have consistently struck down and overturned cases in which perjured testimony has been utilized. The grounds for the perjured testimony is the knowing use by the Commonwealth of allowing Mr. Bradley to testify that he knew who the shooter was with respect to the Florida incident on February 13th of 2013. Specifically, as found in Exhibit 311, there is a text message from Mr. Bradley, number 268. Exhibit 311 has been introduced as evidence, and that text message was sent by Mr. Bradley to his attorney, Mr. Pickering. And that text message said, "Now you sure once I withdraw this lawsuit, that won't be held on perjury after I tell the court the truth about me not recalling anything about who shot me." Now, if you remember, I believe it was on redirect, the Commonwealth attempted to explain away through Mr. Bradley that this involved a prior court grand jury hearing. Well, the fact of the matter is that whether or not this testimony was referencing a prior grand jury, it was an admission.
Prior grand jury because he hadn't testified in the grand jury yet.
No, but he was saying that he was about to testify in the grand jury.
Wasn't that October?
No, it was within a matter of weeks, the Bristol County grand jury.
I see.
Okay, and I think if you look at the text message, this was at 8:33:38. The next text message at 8:40 to his lawyer talks specifically about, and is an additional matter with respect to my grand jury testimony. And it was in this context of grand jury testimony that Mr. Bradley was asking the question of his lawyer if he told the truth to the grand jury about not recalling anything about who shot me. Now, that text message was known to the Commonwealth. It was, in fact, provided as discovery to the defense, and as this court has reminded the defense counsel numerous times, that to the extent that disclosure has been made to the defense counsel, we were put on notice as to what information was provided in those disclosures. And what to his admission to his own counsel that Mr. Hernandez shot him. Now, you know, there's an old expression, if it walks like a duck, and it looks like a duck, and it quacks like a duck, it's a duck. And Mr. Bradley, this is clearly perjured testimony before this court. It is one of the most disfavored activity that can occur in a court. Specifically, the United States Supreme Court has consistently held that knowing use of perjured testimony in a criminal procedure violates the fundamental right to due process guaranteed by the United States Constitution. And it went on, the court has gone on to say in United States versus Bagley, stating that perjured testimony is considered material unless failure to disclose it would be harmless beyond a reasonable doubt. There is no question that this isn't harmless lack of disclosure. We're not even alleging disclosure. The Commonwealth knew about it.
Well, there was no lack of disclosure. The
I agree.
text, I take it, was produced in discovery, known to all, and part of the 479 texts that were introduced from the extraction report. So
My point
it's not an
exactly.
issue of concealing perjured testimony. It's an issue, I take it, of whether or not, in fact, there is perjured testimony. Taking the text as evidence, as evidencing that what Mr. Bradley said here was in fact false, and that the Commonwealth knowingly made use of that testimony in advancing its case. Correct?
Yes.
Okay.
I wasn't suggesting. All I was suggesting is that the courts, in retrospect, after trials, in cases where they have overturned convictions for perjury, in those cases alone, it's even just the, not even just, the failure to disclose. In this case, we have disclosure, yet, and they knew as well, yet they proceeded to use perjured testimony. And I don't see, let me continue. The courts have also said, United States v. the Massachusetts Supreme asserting that convictions obtained by the knowing use of perjury are fundamentally unfair and must be set aside if there is any reasonable likelihood that the false testimony could have affected the judgment of the jury. In Pyle versus Kansas, 1942, declaring that the prosecution's knowing use of perjured testimony would deprive the defendant of due process. There's court after court after court in the U.S. Supreme Court and also the Massachusetts Supreme Court. I don't
think I need a primer on the law. Let's accept the proposition that the knowing use of perjured testimony is improper and can cause reversal or warrant dismissal.
Yes, sir.
Let's accept that as the state of the law.
Yes, sir. That's the state of the law.
Okay, so what more do you want to say?
What more that I want to say is that to suggest that the Commonwealth, with a communication from Mr. Bradley to his lawyer, telling the lawyer he was concerned about perjury when he tells the truth that he does not know who shot him, and then the Commonwealth goes on to present a case and allow Mr. Bradley to testify that Mr. Hernandez shot him, is clearly use of perjured testimony and can't be viewed in any other light.
Okay.
Thank you.
Commonwealth?
Your Honor, very briefly, the statement is not evidence of perjured testimony. The court is well aware that instead it's an alleged prior inconsistent statement that was used in cross-examination, and I expect to be mostly argued in closing argument. The statement has to be taken in the context to which Mr. Bradley explained it on redirect. Right after that text is a text about his impending grand jury testimony. Mr. Bradley indicated that he was concerned about settlement negotiations that were ongoing, and whether or not if he withdrew the lawsuit, went into the grand jury, and in essence perjured himself by saying he didn't know who shot him, whether or not that would affect his civil lawsuit, and whether or not he could be charged with perjury for the inconsistent statement. So again, it has to be taken in its context. It is not evidence of perjured testimony, and the motion should be denied.
All right. I recall the back and forth on direct cross-examination and redirect as to this text message and its meaning. Mr. Bradley gave an explanation for what he thought for what he intended to mean in sending that communication, as just referenced by the Commonwealth. The motion assumes that in fact Bradley's testimony here as to knowing who shot him was false and perjured. And I don't make that assumption. Ultimately, that is for the jury to determine. So after hearing this motion is denied. The counsel, before we bring our jurors down, the issue was raised on Monday regarding the testimony or anticipated testimony of, is it Dr. Jamie Downs? Dr. Downs, having provided a report of the opinions he had formed in this case, and then over the weekend amending that report and expanding his report. It was also disclosed that Dr. Downs had in fact been present during the testimony of Dr. Lindstrom, notwithstanding the fact that a sequestration order was in place. And as I've seen the supplemental report of Dr. Downs, it also reflects that he's viewed the video testimony of other witnesses.
Only as to the actual shooting, not the whole testimony. Only as to the nature of the shooting.
Well, he doesn't say what it was, other than he viewed the direct testimony of Mr. Bradley. He reviewed the video testimony of Detective McIsaac. He reviewed the video testimony of, is it Michael Haig, the reconstructionist, and was present throughout the testimony of Dr. Lindstrom. The Commonwealth raised a concern about that and asked at a minimum that it be permitted to meet with Dr. Downs. And you folks, I think we're working that out. Mr. Lee, did you have an opportunity to meet with Dr. Downs?
I did. We were originally scheduled to meet yesterday evening, but his flight was delayed until close to 11 p.m., so I did meet with him this morning for roughly 35-40 minutes.
All right. And do you have any request to the court now?
Well, Your Honor, from having read the report, I think the court probably sees that it's long on observation and relatively short on opinion testimony. I will challenge, as it comes up, certain aspects of the numbered paragraphs that Dr. Downs, if those are elicited. But one of the opinions that he gave in his original report has been, I guess, punched up in a way. It's not the same verbiage that he used in his original opinion, but I can cross-examine him regarding that. But there are a number of numbered paragraphs that I think are inadmissible and inappropriate for the jury's consumption, but I can make those objections when necessary.
So you don't want me to do anything at this stage?
Not at this stage, but to the extent that any new opinion is in that, I'd ask the court to exclude it. But Ms. Kenny Bodden also explained to me that the two major opinions that he's going to be offering to the jury is the number of shots and the relative position of the arm of Mr. Furtado at the time he was shot.
Yeah.
And those are consistent. Those were in his original report. So as far as those opinions are concerned, I can rely on my...
All right. Then I will listen for objections and talk with you folks as they arise.
Your Honor, I also, in the Lane Foundation, we have an exemplar shirt explaining the shots, and in the Lane Foundation, you have to be able to use that shirt in front of the jury.
Have you seen it?
I've seen a picture of the shirt, but I've seen what there's a paragraph devoted to it in the supplemental report. I would object to the exemplar shirt coming in for a variety of reasons.
Just as demo to explain the shots that were indicated in this first report and how the angulation was. As a matter of fact, the demonstration without the shirt was done today with Detective McIsaac, I think, having yellow stickies on his shirt to show the same angulation.
You didn't shoot McIsaac.
Didn't shoot Dr. Downs either, so that's concerned.
Judge, my concern with the shirt is that what Dr. Downs evidently did was take the exemplar shirt and either lay it over or superimpose it upon the Mr. Furtado shirt, and then marked two places and put holes in it and tries to make a comparison regarding the trajectory testified to by Dr. Lindstrom and that as it appears to be on the shirt. The problem is, of course, that there's so many variables involved. There's no way to know how the shirt was being worn or where it was laying across the victim's back at the time he was shot. Sometimes shirts bunch up, and sometimes, quite often, the holes don't even match the holes.
Well, and
in other words, I don't know.
that's an issue whether you use a exemplar shirt or the original shirt that is in evidence. So that's not grounds to exclude it. It seems to me grounds to exclude it would be if indeed it is not substantially similar to the shirt in evidence or the location of whatever it is that is significant. I take it in this case it's the holes are not properly positioned or not similar.
That foundation not be laid in front of the jury, however, because it could be that after the foundational questions it's not admissible.
Well, you go take a look at the shirt, compare it to the original exhibit,
Well, all I have
see if it misrepresents anything to you. That would be the ground to exclude it, and I don't see any other ground to exclude it. I would not permit the shirt to come into evidence. I'd permit it to be marked for identification and serve as an identification exhibit.
No intention to move it. And Your Honor, could we have, before Dr. Downs testifies, I think I notified the court, could we have 5 minutes because we have to move all the electronic equipment down, the cops on to make sure it's not going, because we're dealing with medical examinations.
You can do that now because we're about to get started. Now
They need it, I believe, now for Mr. Green. They need to have access to it. He's
for who?
For the first witness. Dr. Downs is not the first witness, it's the second witness.
And who is the first witness?
Jacob Green. The computer expert.
Oh, yes. Thank you. All right, the last issue before me, before we bring the jurors down, relates to this witness, Lysander Amato. The defense asked me on Monday to recognize process electronically, I guess it was, to a member of the U.S. military now serving in Kuwait. The defendant submitted in support of that request references to the Hague Convention and to U.S. code regulations or laws regarding the fact that an active member of the U.S. military would retain their domicile or residency for purposes of judicial process. Based on what was submitted, I allowed the defendant's request or motion, whatever it may have been. Yesterday, I received in letter form what appears to be a motion to quash by the witness, Mr. Amato. The motion to quash in letter form dated April 4 and addressed to me is on the letterhead of the Department of the Army and Camp Arif Jan in Kuwait. Arif Jan Nancy, Arifjan. And in the letter, this soldier indicates that service of process is not proper in the country of Kuwait because it would rely on a provision of the Hague Convention Kuwait does not recognize, that is, has objected to. Counsel, it's all a way of saying, I don't know why I'm dealing with this issue now on the last day of the defense case. This seems to be an issue that should have been raised far in advance of today, The question is the propriety of process. Based on what has been presented to me by way of the defendant's ex parte memorandum supporting the propriety of process, and in light of the response by Mr. Amato, that I take it was prepared with the assistance of some member of the Judge Advocate General's office. I'm not prepared to issue an order indicating that process is in fact proper to a member of the U.S. military serving in Kuwait. All right. I think that means we're ready for jurors.
But I don't know if we want to address this now, but I did want to be heard briefly on the issue of two recall witnesses who I believe are being called today, one being Mr. McCann and one being Mr. Kwan. I would just ask the court to require counsel to give some offer of proof as to why these witnesses are being recalled. As the court is aware, the court did give counsel the ability to recall certain witnesses at a certain time if it deemed it appropriate. In the Commonwealth's position, if it's just a question that was forgotten to be asked, then it would not be appropriate to allow defense counsel to recall the witnesses, as opposed to if it were actually another area of questioning that counsel was relying upon the Florida rules and intended to recall this witness. I think that would be a different situation. The Commonwealth would ask for some offer of proof as to what these two recall witnesses would be testifying to.
Mr. Baez?
The issue is moot, Judge.
It's moot?
Yes, sir.
You don't intend to call them?
No, sir.
Okay. Very good. Anything else before we bring our jurors down? No? All right, we'll be in brief recess to line up the jurors.
All right, please.